Hi, and welcome to this edition of Beyond the Law. In this edition of Beyond the Law, I'm discussing out of court settlement. For those of you that have cases in court, or for those of you that have family members or friends that have cases in court, you must have heard them come back from court to say that their matter was adjourned for out of court settlement. The question then is, what is out of court settlement? What are the requirements before out of court settlement can be explored? If out of court settlement fails, what happens? Is that the end of the matter? These and many more are the issues I'm addressing in this very edition of You and the Law. What is out of court settlement? Out of court settlement simply means taking a matter from the court and taking it home for the paramount ruler to adjudicate upon it, to see how parties can be settled. Removing a matter from the court for the time being and taking it to a religious leader, highly respected in society, for him to see how he can mediate between the parties, or taking it home for a respected family member to see how he can mediate between the parties, or to any other respected person in society for him to see how he can broker peace between the warring parties, in the matter. So, taking the matter away from the court for the time being to seek possible settlement away from litigation is what is known as out of court, settlement. Now, who can initiate out of court settlement? It can be initiated by the judge. It can also be initiated by a counsel to any of the sides. It can even be initiated by the parties themselves or by any other person who has interest in the matter. Maybe a family head or a father says that two of his children are in court. He goes to court to seek that the matter be given to him for possible settlement out of the courtroom. Now, the judge, having seen the matter presented before him, could go through the documents and also upon listening to the parties could just come to the conclusion that this is one of such matters that can be discussed amicably by the parties outside the courtroom, and so the judge can then decide to say, well, I've seen here that the two of you are brothers. I've seen here that the two of you are cousins. I've seen here that the two of you are from the same family or from the same village, or that the two of you have had a long-standing business relationship over the years. And I have seen that why you are in court is because one or two issues arose, and because of that, you have come to court. And so the judge says, go back and try and see how this matter can be settled. So the judge can initiate it. It can also be initiated by counsel to any of the parties who stands up in court to say, well, my lord, parties seek that this matter be allowed to be taken home for possible out-of-court settlement. So that way, parties will be allowed by the judge to go and discuss the possibility of out-of-court settlement in the matter. Now, the other question is it every matter that can be discussed, that can be settled out of court? Now, here is the answer. Almost every matter can be settled out of court, but mostly civil matters. So, issues of contract, issues of family matters, issues of human rights, and so on and so forth, maritime cases, business matters, and so on, they can be settled out of court. But serious criminal matters cannot be taken from the court and settled at home. Murder, kidnapping, terrorism, treason and treasonable felonies, and many other matters like that cannot be taken from the court and settled out of the court. Why? These are serious offenses against the states. And so parties discussing to say, we have forgiven you, we have done this and that, cannot play to the extent of making a criminal matter of that magnitude to be taken out of the courtroom and settled outside. There's nothing to settle in those ones. Those ones, the cases must be tried fully and judgment given at the end, and then punishment properly apportioned to anybody that has been found culpable. Now, What happens when parties go out to discuss these matters to see the possibility of settlement? If they settle, how do they present that to the court? Now, when a matter is adjourned for out-of-court settlement, the judge also asks for a report of settlement and gives a date for it. On that date, when the matter is coming up for report of settlement, the parties are expected to tell the court if they have settled. If they have settled, then the settlement would have been reduced into writing and signed by the parties. And so the settlement that has been signed by the parties is presented to the court, and then the court is requested to adopt that terms of settlement as being the judgment of the court in the matter. What the court does in practical terms is for the judge to ask this party, does this represent what you signed? He says yes. And ask the other party, does this represent what you signed? And then the party says yes. Once that is done and the judge is satisfied that it is a product of free will, it's not a product of force or compulsion, then the document known as terms of settlement will be adopted as the judgment of the court in the matter. When that is done, parties are bound to abide by the terms of settlement that they freely entered into, and no party will ordinarily be allowed to go further on appeal to challenge what he had already agreed, except maybe the party goes to appeal to say that there is fraud, there is misrepresentation in the terms of settlement. Anything outside that, the party that has accepted terms of settlement will most likely not be allowed to go on appeal to challenge what he had already agreed upon. Now, what happens if parties don't agree to the terms of, to the settlement? If they go out and then they discuss and discuss over and over and there is no settlement, is that the end of the matter? No, that's not the end of the matter. What happens in that situation is that the lawyers will go back to the court and tell the court that settlement has failed. What then happens is that the matter continues for trial. The hearing of the matter continues, and then finally the judge gives judgment. And when judgment is given, it is usually given as a result of, as a product of litigation, and it is only one side that is usually favored in the judgment of a court of law that has come as a result of full-scale litigation. In out-of-court settlement, all the parties, the interests of all the parties are factored in mostly, and so everybody goes home as a winner. But in full litigation, only one side wins. The other side goes home mostly without anything. In court, through full litigation, it's like a case of a winner takes it all. There's no middle ground. There's no common ground. Once the court decides that the evidence in favor of one side outweighs the evidence of the other side, then judgment is delivered in favor of that side that has weightier evidence against the other side. And so the other side, whose evidence is very light, goes home without anything. The one that has very heavy evidence goes home with the judgment of the court. So whereas out-of-court settlement means at the end, all the parties, they have their interests accommodated in the out-of-court settlement, in litigation, only one party goes home smiling. The other party mostly does not go home smiling. Thank you very much for watching this very episode of You and the Law. I do hope you have learned one or two things about the principle of law known as out-of-court settlements, the practice of the courts in Nigeria, in Africa, and in all courts of in all countries of the world, known as out-of-court settlement. I do hope also that if you have a case in court, you should also think in this line to see if it is possible to also have your case settled out of court. If it is possible, mention it to the court, and no court is going to stop you from exploring out-of-court settlement. My name is Ekemi Nudim. I'm a legal practitioner. I am the host of this channel, and I encourage you to subscribe to this channel so that from time to time, I can send you notifications on everything law. Thank you and remain blessed.